Person at the jail, what is your name?
My name is Joshua Hoffman.
All right, this is case number 253657SM, the people of the state of Michigan versus Joshua and Michael Hoffman. We're here for an arraignment. Mr. Hoffman, you met with somebody from the Community Corrections Department and gave them some contact information. Is that information accurate?
Yes, it is.
Did you have the opportunity to meet with somebody from the Defender's Office today?
Yeah, and I did meet with them. I just don't know why I met with them.
Okay. Well, they're required to meet with you. That's probably why.
What events?
What's that?
What events are you speaking on? I'm right here with you. I'm trying to figure out everything along with everyone else. All I know is I was aggravated at my roommate.
Hold on. Mr. Hoffman.
Yes, sir.
Don't say anything. I don't want you to say anything about the case, all right? Because we're making a record and the prosecutor's present, so I don't want you to say anything that could cause some issues for you. So
yes, Judge. Yes, Judge.
Let me do what I need to do, and I think that's going to answer your question for you, all right?
Sir.
So I have a complaint that alleges that on or about August 10th, 2025, in the city of Cadillac here in Wexford County, it is alleged that you did commit the offense of domestic violence upon William Scott, a resident or former resident of your household. That is a 93-day misdemeanor and or a fine of $500 with consecutive sentencing may be imposed if the assault happened in place of confinement. Mr. Hoffman, I'm not asking you if you agree with the charges, but do you understand that is what you've been charged with, and that is
I would like to press charges if that's what I am being charged
Mr. Hoffman, this is going to go a lot easier.
I have a right to speak, do I not, Judge?
You absolutely have the right to remain seated, stay calm, and allow your attorney to speak on your behalf. In a courtroom setting, silence is often the smartest move, especially during critical moments. Every additional comment you make can work against you, even if you believe you are helping your case. Judges carefully observe behavior, tone, and attitude, and unnecessary talking can easily be interpreted the wrong way. In many cases, speaking out of turn only increases the risk of stricter conditions, including a higher bond. The courtroom rewards restraint, not interruptions, and letting your lawyer handle the conversation is usually the safest strategy.
Not at this point, you don't.
Why
Mr.
not?
Hoffman? Mr. Hoffman,
I would like
process.
to
Corrections, I have a docket I have to get through, so can we put Mr. Hoffman back in his cell, and I will get back with him.
Sir, I'm asking you a simple question. Can I press charges against him?
Thank you, Corrections. All right, we are back on the record in the people of the state of Michigan versus Joshua and Michael Hoffman, case number 253657SM. Ms. Lawrence joins us in the courtroom. Mr. Hartel, are you able to see and hear the court?
I am, Your Honor. Thank you.
And Mr. Hoffman, are you able to see and hear the court?
Yes, Your Honor. I'm able to see and hear the court.
Mr. Hoffman, I know you had a lot that you wanted to get off your chest. I want to just let you know that I am not the person that you need to talk to about filing charges. You can talk to law enforcement about that, or you can talk, if you decide that you want an attorney, you can talk to your attorney about that as well, all right?
Okay.
So I had left off with you, the last thing I recall was that we had gotten through the charge and I had read the penalties, and you acknowledged that you at least understood the penalties in the charge. Is that accurate? Not that you agree with it, but that you understand that that's what you've been charged with.
Can I ask what the charge is again?
So the charge is domestic violence, that you did make an assault or assault and battery upon William Scott, a resident or former resident of your household. That is a 93-day misdemeanor and or a fine of $500 with a consecutive sentencing might be imposed if it happened in a place of confinement, which is essentially jail. So we know that that doesn't apply. Do you understand those charges and the potential penalties? Not if you agree with them, but do you understand that's what you've been charged?
Yes, Your Honor. Absolutely, I do.
I can't remember. Did I ask you if you had signed an advice of rights form, talked about your rights to a trial and your rights to an attorney?
No, you had. Yeah, I signed that with Mr. Robert Hartle. There, did I not sign that with you? That's my attorney right there, right? Ain't that what we did earlier?
He's not your attorney.
If he's not my attorney, then I want this stopped until I have an attorney,
Hold
right? I have the right to do that, right?
on, hold on. let the
I'm not
judge talk.
answering any more questions.
That's fine, just let the judge talk.
It's easy to see why you're frustrated, but it's clear there's some confusion about what's happening right now. This moment is an arraignment, not a trial, and the purpose is very limited in scope at this stage. The court is not deciding guilt or innocence, and no arguments about the facts of the case are being made. The court-appointed attorney is present for one specific reason: to address initial matters, including requesting a lower bond or fair release conditions. That attorney may represent you later, or the court could assign someone else as the case moves forward. What matters right now is understanding the process and letting it unfold step by step, rather than reacting based on assumptions about how the case will ultimately be handled.
All right, so since we're not sure whether or not you've gotten your pretrial rights, I'm going to go through those with you. If you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make arrangements. You have been brought to court on a misdemeanor charge and you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court, to have a trial by jury, and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, which means without money to hire an attorney, and if the offense charged requires a minimum jail sentence, or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay a portion of the expense of the appointed attorney. You may contest your ability to pay that ordered fee if the court attempts to collect any cost for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify, to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead no contest or guilty and your plea is accepted, you will not have a trial of any kind and you'll be given up the rights that we just went through. You also have the right to be released on bond, and we'll get to that in a moment. If you are now on probation or parole and you enter a plea of guilty or no contest, where a finding of guilt is made by the judge or jury, it may result in a violation of your probation or parole.
Plead not guilty. Plead not guilty.
All right, still have to go through these. You can be sentenced to jail fines plus costs. The courts will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail fines or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows for otherwise for good cause shown. An appeal to the circuit court may be taken within 21 days from the date of sentence, pursuant to court rule. If the sentence includes incarceration, if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days after sentencing. Federal law and/or state law may prohibit you from purchasing or possessing ammunition or a firearm, including a rifle, pistol, or revolver. If you are convicted of a misdemeanor crime of violence and you are or were a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Do you understand those rights that I just went through?
I don't understand any of that. Can you read it again? I didn't understand any of that. I'm gonna need
corrections.
you to read.
Let's do this. Let's hand him an advice of rights sheet and let him read that then.
I don't read too
Yes,
well.
sir.
I got a 7th grade education, sir.
All right, so what I'm going to do is I'm going to put
record right now.
I'm going to put you and Mr. Hartel in a breakout room.
That
and he
doesn't
can
work.
go
I
over
don't know how to read. I'm telling you that. 7th grade education. What was all that you just said to me, sir? Can I speak to you, Honorable Corey J. Wiggins?
Once again, Wiggins attempts to push the issue, but the court shuts it down immediately. At that point, the judge decides enough is enough and moves the process forward. The judge sends him into a private breakout room so the arraignment attorney can clearly explain his actual rights and what this hearing is truly about. This step is meant to slow things down and prevent further confusion or disruption. After that brief private discussion, the court reconvenes, and the proceedings resume with Wiggins returning to the session. With everyone back on the record, The hearing continues, setting the stage for the next exchange.
Mr. Hartel, I have closed the breakout room, so he should be joining us in about 30 seconds or so.
Thank you, Your Honor.
All right, we are back on the record in the people of the state of Michigan versus Joshua and Michael Hoffman, case number 253657 SM. Mr. Hartel, are you able to see and hear the court?
I am. Thank you, Your Honor.
And Mr. Hoffman, are you able to see and hear the court?
Yeah. Yes, Your Honor.
Mr. Hartel, did you have the opportunity to go through Mr. Hoffman's rights with him?
We did go over those, yes, Your Honor.
All right, Mr. Hoffman, did you understand those rights as your attorney went through them with you?
Yes, Your Honor.
All right. You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one will be appointed to represent you, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, request the appointment of an attorney, or represent yourself?
Whatever is going to expedite the process and get me kicked over so I'm not doing dead time on parole.
Well, the choice is yours. I can't make that decision for you.
What was the question again?
Do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
The appointment of an attorney, along with my end of a plea of no guilty right now.
The court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a pretrial. That is where your appointed attorney and a representative from the prosecutor's office will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, historically, I show in 2012 an operating while visibly impaired, in 14 a driving while license suspended, in 17 an operating or maintaining a lab in possession of meth, 18 UDAA, and a B&E of a building with intent, in 17 2 B&Es with intent, an assault and battery, and then 3 more B&Es with intent. In 20, there was a use of a controlled substance, 20 an assault and battery, and malicious destruction of building.
27, excuse me, sir. Apologies.
In 23, a larceny less than $200. In 22, a resist and obstruct. There was a 7411 case in 2012. In 10, there was a shoplifting, which was out of state. And in 17, there was a fail to appear for a fingerprintable charge. He is currently.
Sir, why are we going over all this right now? This is an advice of rights. What you just did right there is totally against the law, and you have no right to be mentioning evidence from prior cases in this case without me being found guilty first. I have a right to have all this expunged from the record, and this will be on the record. I will mark. What time is it?
At this point, it's time to pause and actually understand what's happening in the courtroom. Repeated claims about rights violations don't change the situation, especially when no violation has occurred. The court is following standard procedure, not acting outside its authority. The judge is reviewing your criminal history for a very specific and lawful reason, determining an appropriate bond. This review is not punishment, nor is it a personal attack. It is a required part of assessing risk and ensuring public safety. When a criminal record stretches back many years, it signals to the court that there may be a higher chance of noncompliance or failure to appear. Based on that history, the judge is justified in viewing you as a potential flight risk. As a result, release is unlikely, and the court makes it clear that you will not be leaving anytime soon.
1524.
1524.
Defendant is also on parole with the state of Michigan for the B&E with intents and UDAA. Corrections, is there a hold on him?
Yes, there currently is a parole detainer.
I don't blame him. What happened was, Your Honor, is I was going to leave the house. My roommate had my
Mr. Hoffman, you
bag.
have the right to remain silent. I don't want you to say anything that can be used against you.
This shit sucks.
Any comment regarding bond, Mr. Hartel?
Talk to me in person.
Yes, Your Honor. Thank you. As was noted, I do believe there is a parole hold on this defendant, so some of this argument may be academic. However, I would ask the court to set a small nominal amount of bond so that if he is able to resolve his other issues, that he would be able to then be able to afford the bond, perhaps $100, something very nominal like that. I believe that if the court had any concerns for public safety, they could be overcome with bond conditions and no contact order with the alleged victim. My apologies. I'm not trying to take anything away from his defense strategy, and whoever's assigned, be it myself or someone else, will go over that with him later. But I would again ask the court to keep the bond as low as possible. Thank you.
Thank you. Prosecutor's office.
Your Honor, I'll try and keep this short. This was allegedly between the defendant and his roommate. He had pushed his roommate down the stairs, accused him of taking his marijuana vape. We would ask for a no contact order with the victim. Additionally, given the defendant's extremely long criminal history, as well as the fact he is on parole, I did speak with Mr. Saladay briefly, and he did inform me this is not the first issue he has had with the defendant being on parole. Given that, then people would ask for a $5,000 bond. Thank you.
You said this is allegedly over a vape pen? Marijuana pen?
Marijuana vape, yes.
All right, the court will set bond as follows. Mr. Hoffman, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm going to order no controlled substances, including recreational marijuana. You'll be subject to random testing. There will be a no contact with William Scott. No contact means no contact of any kind, not by you, not by phone, Facebook, Messenger, any other social media, or anybody acting on your behalf. Defendant is not to act in a threatening, intimidating, or harassing behavior. The defendant does have a couple assaultive crimes in his past. An assault and battery in 20, an assault and battery in 17, resist and obstruct in 22. So I do find that a monetary bond is appropriate. I will set a cash or surety bond at $2,500 cash surety. And I should have mentioned also that I had reviewed the praxis, and the praxis scores him at a risk level 3, which is medium risk. I believe that is properly scored, at least given the information that we have. All right, Mr. Hoffman, you'll be receiving your next court date there at the jail. If you are able to post bond, you'll need to report to community corrections here at the courthouse and get signed up for testing.
While you remain in custody for an alleged incident involving a serious physical altercation with your roommate, this time could be used far more productively. Enrolling in anger management programs may help address the behavior that led to this situation, and pursuing a GED could provide a better understanding of how the legal system actually works. Knowing your real rights, rather than relying on misinformation, can make a meaningful difference going forward from there. We shift our focus to Judge Hammond's courtroom, where a familiar figure makes another appearance. A self-proclaimed sovereign citizen returns, once again voicing complaints about not receiving discovery materials in the case that in response. The judge instructs the prosecutor to provide the requested documents immediately. However, in a surprising turn, the defendant then refuses to accept them, creating yet another contradiction that highlights the ongoing confusion surrounding his legal strategy.
All right, Attorney Stoltman, Ms. Renfro, let's call this one more time and try to figure this out. One more time. This is 25F00373OM, 25F00141I, and 25F00394OI. People of the city of Burton versus Christopher Allen Renfro. Attorney Stoltman, if you can place your appearance on the record, please.
Morning, Judge. Attorney Benjamin Stoltman, still on behalf of the people of the city of Burton.
All right, Mr. Renfro, if you can state your name.
Christopher Allen, Counsel Renfro.
All right, thank you. So you called this case earlier, had a pretty lengthy discussion. This is going to be a very short discussion. Mr. Renfro, you had stated that you wanted an adjournment of the jury trial date because you did not have discovery. You did not have some body camera footage that you had wanted, and you did not have the police report, even though it was offered to you previously and you said you didn't want it. You did say that you wanted it today. And so you had requested, and I granted your request to put the jury trial over to September 4th. But then when we got towards the end of the hearing, you stated that never mind, you wanted your trial today. And so I want to give you a few minutes to think about that. What do you want to do?
Well,
No, hold on. Before you start saying a bunch of things that we've already talked about, I don't want to hear anything about jurisdiction. I don't want to hear anything about due process rights. I don't want to hear anything about that. I want to know, do you want to have your jury trial today or on September 4th? That is it.
I'll take the later date because I'd like to practice. No, I'll present my cause. Excuse me. I'd like to get my facts in order so I can defend myself properly.
That's a great idea. I agree wholeheartedly that that is what you should do. I would not want you to go to trial without the discovery that you want. That would just be very unwise. So I am going to grant the request then. So we will set this matter, I'll find good cause to adjourn. We'll set the jury trial on September 4th, 2025, 8:30 a.m. We will also set the 2 formal hearings like we've talked about before on that date as well. My plan is to do the jury trial first so we can get the jury in and upon their way as soon as possible, and then we'll do the 2 formal hearings. It might so happen that we'll have to do the formal hearings on the day after that, on the Friday, because the jury trial might take the whole day. But we should have both days free to do so. All right, is there anything else in regards to scheduling or discovery that we need to talk about before we end here today? Attorney Stolman?
Nothing for me.
Mr. Renfro?
I'd like any and all documentation within the discovery warrant, amongst other things. I don't know what's in there. I do know there's a warrant. I just want to make sure any and all documents inside the discovery is disclosed to me.
I think what Attorney Stolman says, so one, I want to state one more time that there has been no written request for discovery, and previously when discovery was offered to you on the record, you said you didn't want it. I just want to make sure we have that on the record, but today you're saying that you do want those things, and I am accepting your request on the record in lieu of a written request for discovery. Attorney Stolman said that he didn't have a problem with that, correct?
Correct.
And so I also heard Attorney Stolman state that he would give you the documentation that they have in their file in regards to discovery, is that right?
Yes, sir.
Okay, so you'll get what they have, which I believe should be a complaint, a warrant,
Please report.
police report.
To correct the record also, I did say I didn't want to go to jury. I never said I didn't want the discovery.
That hearing was brief and largely procedural, but it's still important to cover it. Even short appearances can shape what happens next, and many viewers want a complete picture before the case reaches trial. Providing this context helps clarify how the process is unfolding behind the scenes that we now attain to the final courtroom appearance of the day, which involves a defendant appearing before Judge Perkins. Throughout the hearing, her conduct made the proceedings unnecessarily difficult and strained the court's patience. When the judge temporarily set the matter aside to manage the situation, she chose not to remain in the courtroom. That decision, driven by her refusal to cooperate, ultimately worked against her and added yet another complication to an already tense hearing.
If you want discovery, because you just stated you wanted discovery, so if you want discovery, I'm gonna make sure it happens. So if you want discovery, how do you want to give it to you?
I don't. We're past the cutoff line and I want to vacate.
He doesn't want it. All right, well, if you don't want discovery, that's fine.
Discovery is one of the most important things on the case to defend myself.
You did though. You did though. If you ordered the transcript, you would see that Attorney Odette offered discovery. You said, I don't want it. You had an argument that it was past the discovery deadline, but the discovery deadline is actually for you to request discovery and then for them to provide it to you. If you don't request it, they don't provide it, right? So she stated they tried to give it to you. You said you didn't want it. I said, do you want it now? You said, no, I don't want it. And I said, he doesn't want it. And then we moved on. Right, so that is what happened. If you order the transcript, that's what it will reflect. But it doesn't matter in this one, because you're gonna get the discovery, okay? All right, and that's all for today. Thank you.
It appears she will be given an opportunity to speak with the prosecutor and potentially resolve the matter outside of further court conflict. While that option is on the table, past behavior suggests cooperation may be unlikely, as some defendants enter court convinced they understand the system better than anyone else. Unfortunately, that confidence often disappears when real consequences follow. For the sake of her daughter, one can only hope she accepts the assistance of a court-appointed attorney and agrees to a resolution that keeps her out of custody. A stable outcome would allow her to remain present in her child's life rather than continuing a cycle that leads back to jail. Legal guidance at this stage could make all the difference. That brings us to the conclusion of today's courtroom coverage. I'll continue tracking these cases and provide updates as they return before the court. If you found the video informative, consider leaving a like. If not, feel free to share your thoughts as well. Either way, don't forget to comment and subscribe with notifications enabled so you don't miss future updates. This is Team Skeptic, signing off.
Destiny, are you there? Is your device working now?
I'm sorry.
What is your full name?
I am Destiny Graves. That's capital D, lowercase e, S T I N E Y. Hold on, boo. I'm sorry. Well, give me a minute. That's capital D, lowercase.
Yes, you can. All right, thank you.
Hello?
I'm sorry. No problem.
Hold on. I'm just talking.
Hello?
Hold on a second. This is the City of Detroit versus Destiny Raven Graves, case number SP 1069059. Counts 1, counts 2, SP 1724805, counts 1, 2, and 3, SP 1724831. State your name for the record, please, ma'am.
For the record, I am capital D, lowercase e, S T I N E Y, dash capital R, lowercase A I V Y N, colon capital G, lowercase R A V E S, and I am appearing specially, not generally. I am here in good faith to address the matter of jurisdiction before any other proceedings.
All right. Today is the date and time set for a show cause. You missed your last court appearance.
No, I appeared. What was it? Not just past the matter.
Yeah, but you left, man. You left without waiting on me to recall your case.
Oh, because I had spoke with your secretary.
You don't speak with anybody but me. I give you the authority to leave or not.
Yeah, I wasn't aware of what to do, what my next steps were to do. So I did send a letter to the clerk so that I could figure out what my next steps were, because I was confused on what past the matter was, and I didn't want to.
You need to hire yourself a lawyer, ma'am, or if you don't know the procedure, or learn the rules of the court rules.
Understood, Your Honor.
All right, so what do you want to do? Do you want an offer or you want a trial date?
I'm sorry?
Do you want an offer on these matters or do you want a trial date?
Honestly, Your Honor, I would like to establish proper jurisdiction before moving on.
All right, the jurisdiction in the court's eyes is established. You got notice, right?
Notice in what way?
You got notified by the court that you had to be here, right?
Was I notified by the court?
You got a ticket, ma'am. So let's just.
I did have a ticket, but I did not sign any. I did not sign over my rights or anything, so I didn't.
You haven't given up any of your rights. Now, do you want to speak to a lawyer or not?
No, Your Honor.
All right, so either you have two options now. I can let you speak to the city attorney yourself. You have three options. You can plead as charged to all the matters. I can let you speak to the city attorney yourself, and you can try to work out a deal for yourself, or I'm going to set a jury trial date. Which one of the three options do you want?
You said I can take a plea, speak to an attorney, or set a jury trial date?
You can take a plea you can plead as charged. You can speak with an attorney if you just said you didn't want to speak to the attorney. But you can speak to the attorney, that gives you four options. You can plead as charged, you can speak to an attorney, you can speak to the city attorney yourself and try to work out the matter yourself with the city attorney, or you can set it for a jury trial. I'm not even gonna set it for a bench trial. Just set it for a jury trial. Which one do you want? All right, I'm gonna pass it unless you.
I wanna write it down. I'm trying to figure it out.
All right, I'll pass it until you figure it out.
Okay.
Raise your hand in the chat once you figure it out.
Okay.
Let's pass the matter. All right, let's go back on the record with Miss Raven Gibson. Miss Destiny Raven Gibson. Ms. Gibson, I'm giving you an opportunity to make your mind up which one to do. What would you like to do?
Thank you, Your Honor. It's not Gibson.
No, Graves, I'm sorry. Destiny Graves, I'm sorry. All right, go ahead, ma'am. What do you want to do?
I'm sorry?
What do you want to do?
Okay, I just want to say thank you for allowing me a moment to gather my thoughts. I am Destiny Graves, Destiny Raven Graves. That's capital D, lowercase ESTINEY, dash, capital R, lowercase AIVYN, colon, capital G, lowercase RAVES. I am appearing specially, not generally.
With the extra special and specially. And I love how she smiles when she spells her name. It's like she's so proud of herself for getting it right this time.
I do not waive any of my rights. I am here to set a pretrial date under protest and to preserve my challenge to jurisdiction and proper identification. I respectfully ask that my objections remain on the record and that my appearance today not be interpreted as a waiver of those rights. I am ready to proceed with pretrial while maintaining these protections. Thank you, Your Honor.
All right, so I gave you four options. Which other options did you want to take? That's what I gave you time to figure out. You said all that other stuff. Your objection is noted on the record. So you said all that other stuff.
Right, I said that I will do a pretrial. I will set a pretrial date.
No, the day is the date and time set for pretrial. No. You're gonna either set it for trial. You're either gonna I'm giving you, here are the options. We're gonna treat today like a pretrial date. On a pretrial date, that's the date where you go and speak with the city attorney and try to work out a deal. Obviously, it's obvious that you are not interested in working out a deal because you probably just want all the cases dismissed because you feel that you have the legal authority to drive or to ride on a cell phone and move around the city. You don't feel these allegations apply to you. So
no, Your Honor, it's not that I feel that they don't apply to me.
Wait a minute. Either you're going to get a deal with the city attorney today. They're going to do this one more time. You're going to get a deal with the city attorney today. You're going to speak to an attorney in the breakout room so they can secure a deal for you. You're going to set a jury trial, or you're going to plead guilty to everything. Those are your four options. Which one do you want?
Your Honor, unfortunately, I do not consent to move forward without showing proper jurisdiction over my living person.
All right, give me a jury trial date, please.
I'm sorry?
I'm gonna set a jury trial date now. And you're gonna be in person. You're gonna have to come in person for this next court hearing.
And what date would this be? As can I also say that Well, I also would like to add that I would like for my rights to be preserved under the process.
Your rights are gonna be preserved. You haven't taken a plea at all today or not.
Okay.
Excuse me, Your Honor, are you going to appoint standby counsel for a jury trial?
I don't think that is even necessary. I don't know. Do you want me to appoint you to this, Mrs. Soroki?
No, thank you. I don't do the assigned jury trials.
Oh, I gotta go through the MDIC anyway.
We can do September the 16th.
September the 16th. September the 16th is gonna be the jury trial date. That's gonna be in person on September the 16th, okay?
September 16th in person, what time?
At, we'll just say 8:30. Then I'm gonna set 2 other dates. I'm gonna set a motion here. I don't think that's necessary, but I'll set it anyway. Motion hearing date. Oh, no, I'll just set a final pretrial date. Final pretrial date will be the day before on September the 15th. So.
Okay, you said, say it again, a trial.
I'm gonna give it to you all. And so final pretrial date, write this down, ma'am. Final pretrial date is gonna be September 15th. You do not have to appear in person. You can come online then, but I do want all parties to appear. Ms. Snyder, are you there?
Alexa Schneider for the people, P80322. I'm here. Is this Destiny Graves?
Yes.
Okay, thank you.
So make sure if your officers choose to, if they don't, we'll dismiss the case on the final pretrial date. Ms. Graves, all parties are going to appear on final pretrial date. And then we'll set a jury trial on September the 16th, 2025. Do I need to appoint? Do you want me to appoint an attorney to you to stand by and assist you on this, ma'am?
Sure, but I don't think it's needed, but we can we'll proceed with that if you like.
I don't know. Do you have a number that you can be contacted at?
Yes.
What's the number?
313 76.
All right. I'll try to see if we can get an appointed attorney. But we'll just set a pretrial on. So come back on the date. 28th is, we're gonna add another court date, the 28th of August. Come back on the 28th of August, answer the calls you don't recognize. Hopefully one of those calls should be that appointed attorney. And that date is set just to make sure that you've had contact with that attorney, okay?
Okay. So I just want to confirm real fast.
Go ahead.
September 16th, jury trial date for 8:30 in person. And then the final pre-trial September 15th on Zoom. What time would that be?
At 8:30.
Okay.
And then another pre-trial date for the purposes of making sure that attorney has contacted you. I need you to answer the calls you don't recognize. One of those calls should be that appointed attorney. If that appointed attorney does not contact you by that date, then we will try to get one appointed to you on the spot on that date, okay? That would be on August the 28th. So you have August the 28th, September the 15th, and September the 16th.
Is it the same time?
8:30, yes.
Okay, thank you.
All right, Ms. Pro, have a very good day. Best of luck to you.
You too.
All right.